Hi, this is Jenn with CarePatrol. I'm here with Deborah. Deborah is a care manager who really helps with guardianship. Today, we're going to be talking about the difference between guardianship and power of attorney and conservatorship, really focusing on guardianship today. Thank you for coming, Deborah.
Thank you for having me here.
Can we start with just what is a guardian?
Let's start with the person. So the person has been deemed incompetent, as you would say, for needing somebody to make decisions for them. So a guardian is somebody that steps in, helps make decisions for them, helps their overall, their housing, their safety first, but above all, their basic decision-making needs. So that could include like their medical placement, their housing.
So I think one of the things that's really confusing for a lot of people is the difference between a power of attorney and a guardian. On a power of attorney, someone has to be competent and they deem this person can make decisions for me when I'm no longer able to. Right. So a guardianship is different, right?
Yes, a guardian is court appointed. So say someone has a situation where they don't have family involved, or say they do have family involved, but the family is not making the best interest for this person, then the court will appoint a guardian to make the decisions for the person.
And we've had situations where there is a power of attorney, but that power of attorney is not comfortable, not willing, not able to really take care of a client. So a guardian can step in then too, right? Like the power of attorney can hire a guardian, or how does that work?
So anybody can petition a court to become guardian. And so like a power of attorney is somebody that they've chosen this person to be a power of attorney for them, and they can make the medical decisions once the doctor, the physician, determines that this person is incapable to make the decisions for themselves. Say there's somebody at the hospital and they're very, they're not with it right at the moment. They're very poor insight to their care. Then they will get the power of attorney involved. If somebody needs a guardian, then they have to petition it to the court. Sometimes there's situations like at the hospital where somebody's at the hospital, can't go home because it's not safe. Then they will petition the courts to they'll find a guardian and then petition the courts to have that person to become guardian.
CarePatrol often works with guardians and power of attorney, medical power of attorney. We also work with financial power of attorneys and conservators. So again, the way I understand it is a financial power of attorney is someone who the client was competent enough to say this person is making these decisions for my financial well-being. And this sometimes is a different person than the medical power of attorney. Then how does it work with a guardian? Is there always a financial power of attorney, or then do you go to conservatorship? How does that work?
It depends on the situation. So if there's like finances involved with the person and they have assets, then usually there will become a conservator, which is also court appointed. If somebody has like their medical, it's always medical, and then like a medical power of attorney is always medical, and then the financial power of attorney, like a POA is a general POA, then they would be the ones that can make the determination of the person. As long as there's not a court order for that, then they can make that determination for them. As long as there's like a notary, somebody saying that they want this person to be their financial power of attorney, if that makes sense.
So the difference between a financial power of attorney and conservator is kind of the same. Court appointed for conservator.
Yes.
Financial power of attorney, you gave them
the authority
mm-hmm. while you were competent.
Yes. Now, say a person ends up having to get a court-ordered guardian or a court-ordered conservator, that will trump the one that was put in place by the person.
The power of attorney. So a guardian and a conservator trumps the power of attorneys.
Yep, and the medical power of attorneys, yep.
We should talk about that. Guardianship is kind of a scary idea for a lot of people. And I don't think people realize if you're competent and you pick a power of attorney to make your decisions, that power of attorney only comes in place when you're not able to make decisions. And a guardianship is like, there's no way for a guardian to take over someone that's competent or to take over a power of attorney that's doing a good job.
No. They wouldn't come and step in if there's a person taking a job. The courts want families to actually be making the decisions if they can. If there's a possibility of the person having a good family member that could, look at the best interest of the person, they're going to choose that family over a professional guardian any day. So, but there are professional guardians because of sometimes the family dynamics, because the person doesn't have families. So, there is a reason that we have the professional guardians and not always families being the guardian. But the courts would rather it be a family member that's making the best decision for them. And they won't step in place unless there's a reason for it.
Yeah, and the only guardianship only comes into play when the client is not able to take care of themselves physically, mentally, emotionally, financially, and doesn't have someone else,
right,
that's able to do it,
right. And then there's sometimes, you get situations where like a family member who is like just general POA, sometimes they need to sell the house or, do some major decision making. They may have to request being the conservator themselves. And the family member might be who is in the best interest of that person. Maybe there's another family member who's trying to overstep, the boundaries as well. And so sometimes the families request to become the guardian as well, just to have that protection over that person.
So I think when there's family involved and a guardian is in place, sometimes the family is left with, what do I do?
Right. So that's a tricky question sometimes because families feel like they're, they don't have any say. If you're a good guardian, you're going to look at what the family is saying because they know them best. But at the same time, it's really the guardian who makes that final decision for that person. If I have a situation where I have a client who has disabilities, lives in a host home, I go and do family visits with that person just so they can see their mother. I have another situation where the family lives out of state and they hired us as a guardian, and we go 3 times a week per the wishes of the family to do FaceTimes with the families who live out of state. I mean, that's important to that person to have their loved ones involved. Now, there's been situations where we've had loved ones get involved and they've ran off all the caregivers, and then eventually we have to unfortunately have them step out because they just are not, looking at the best interest of that person in their care.
Client themselves can't pick a guardian because if you're needing a guardian, you're not competent to make decisions at this point. So who is it that picks a guardian?
If they don't have families, it's the person who's taking care of that person at the time. Like say, again, a hospital, a family member could be requesting a guardian because they might be living out of state, or they might be just unable to make those decisions all the time for them. So then families will come together and choose a professional guardian at times for that. Sometimes it'll be the conservators, and if a conservator is not in place, like there was this situation, I'll give you an example. So I was at a nursing home and I was the director of social work at the nursing home at the time. We needed to have, especially during COVID, a guardian. So I went around and I asked guardians if they were willing to take on this client, and whoever did, then we got the attorney involved, and then we went to court, petitioned it, and they have a guardian ad litem that the court appoints that will come talk to the person that they're talking about, the ward, they call it. Um, so it's a protected person in the eyes of the court. So there's guardian ad litem that are involved. There are attorneys that are involved. So physicians that, make statements. So it could be anyone that's concerned about the person.
We also have had cases where there's a bunch of family members involved, and they can't agree, and they need a spokesperson. And sometimes the guardian's a great way of the family all agreeing that this person's going to make the decision.
Correct.
So I've seen that
And
too.
sometimes it's difficult when all the family does not agree with the guardianship.
Yeah.
So sometimes the courts have to come and get involved with that too.
How do guardians get compensated?
So if a person has a guardian, they do get charged an hourly rate. It goes by the attorney, kind of like the attorney fees of 0.1 increments, 0.2, 0.3. So say it's like I'm doing a phone call for, less than 6 minutes, it's still going to be charged that 0.1. But say if I'm getting, I have the full 6 minutes, it's still charged 0.1.
The individuals that have very minimal funds or no funds, how does that work if they need a guardian?
A person with no funds, the family would have to find a guardian that would be able to take a pro bono case. There's cases like the Office of Public Guardianship, but they're specific to only Denver County. I wish that more counties had pilot programs that do accept guardianships, but there's just not a lot out there. So if you can find a guardian that's willing to be pro bono, it doesn't have to be a professional guardian. I mean, it could be a family member, it could be somebody that they went to church with. Anyone who's really concerned about that individual and has their best interest at heart can be guardians. So even if it's pro bono, or the person
so what
has
happens
no
in the other county for clients who don't have family, they don't have anyone stepping in?
Then whoever is concerned about that person, because this person's been in a situation where people are concerned about them, right? They're like, oh my gosh, they can't go home. There has to be somebody in place to make their decisions. That person who's concerned about them can either be the guardian and petition the courts for a guardianship, or they can find somebody to be the guardian for that person. And there's, like I said, there's a lot of people out in our communities that just don't have anyone.
Yeah.
And so the hospitals are honestly kind of responsible. They can't discharge a person unsafe. So sometimes the hospitals will pay for the guardianship. Just depends on the person and how severe and how quickly they want to get them out of the hospital as well. We have situations all the time that a person comes incompetent into a nursing facility and all of a sudden they're not competent anymore. Well, who's to make that decision for them? So it's difficult because they're still the nursing home's responsible then for that person. You want to always, it's really not ethical to have just one person doing all your financials and all your medical decisions, because that person can just step out and take your monies. I mean, it's always a scary situation, and hopefully it doesn't happen, but it's been known to happen. So that's why there's always a guardian, and that's why there's a conservator. Same with the medical power of attorney. You want to make sure you have a medical power of attorney that you really trust to make your best decisions for you, and that's going to follow your wishes. I mean, your wishes is in your living will, so it's important to have a living will. It's important to have your medical power of attorney in place, and it's very important to have a POA that you trust. And then there's situations where, say, that medical power of attorney is noticing something's not going right with that POA, then they can request a conservator. Vice versa. So it's always really important to have all those documents in place.
And I think for the power of attorney, both medical and financial, to know your wishes,
right,
and have that conversation, and to have their own paperwork, right, their own copies in a place where they can find it if something happens. I've had clients where someone ended up in the hospital and they couldn't find their paperwork.
Right. It's always important to put your papers and your financial information in one good briefcase or in your computer under a file, but definitely having them there so that people can find them. The other thing is making sure that you have, even your most form, which is a Colorado most form, is to decide if you're going to be resuscitated or not. You may not want to be resuscitated. It's important to have that in your house on your fridge if they come in and they find you unresponsive. I mean, there's all kinds of different scenarios, and it's important to let your physician know your wishes as well. And there's a thing called 5 wishes. So I think that's a really important document to do for people, because it shows them exactly like what kind of music they want and what kind, who they want their power of attorney to be, or not power of attorney, but their medical decision in place. So
Deborah, thank you for coming and speaking with us. I think hopefully we answered some of the questions that people have about what guardianship is and how it comes into play. If people have further questions or if they want to get in touch with your company, how should they find you?
So I'm Deborah Henry with Care Management Advocates, and you can call 303-331-6422, and you can hit extension 1 or 2. Don Bermania is the owner of our company, and then my extension is number 2. So 303-331-6422, extension number 2. We also have a website. It's cmacalm.com.